I'm going to talk about who is the first owner of a copyright work, including a computer-generated work, how to make sure that the work is transferred properly to another owner, what is a substantial part for the purposes of infringement and the boundaries of fair dealing, and the risks of copyright infringement when training generative AI. For the purposes of literary, dramatic, musical, and artistic works, there are 4 elements to the test of joint authorship. These were identified in the Court of Appeal decision of Martin versus Kogan of 2019, where Lord Justice Floyd said that there were 4 elements to the test of joint authorship. These are listed on the slide. Note that there's considerable overlap between these elements. Let's have a look at these in more detail. In the judgment, collaboration meant people jointly creating the work with a common design as to its general outline and sharing the labour of working it out. Derivative works did not qualify. Each collaborator must be an author in the sense of Section 9 of the Copyright Designs and Patents Act. It was never enough to ask who did the writing when assessing collaboration to create literary or artistic work. An author included those who contributed significantly to creating, selecting, or gathering together the detailed concepts or emotions that the words fixed in writing. Contributions that were not authorial did not count. The question of what was enough of a contribution turned on whether the person had demonstrated their own intellectual creation. The contribution of a putative joint author must not be distinct. The authors did not need to have a subjective intention to create a work of joint authorship. The fact that one of the authors had the final say was not conclusive. Now, when it comes to joint authorship of films and broadcasts, the Copyright Designs and Patents Act specifically states how these will be treated. A film that's made on or after the 1st of July 1994 will always be treated as a work of joint authorship unless the producer and principal director are the same person. That's Section 10(1)(a) of the copyright legislation. A broadcast will also be treated as a work of joint authorship when more than one person made the broadcast. That's Section 2 of the Copyright Designs and Patents Act.